Hello, everybody. My name is Riznyk, and I want to discuss living trusts with you. It's an area nobody likes to discuss. Even when our clients make an appointment, we create everything for them, they don't show up. I know it's a difficult area, but it's also a very important area because I've seen a lot of things happen. The worst thing that you can do is not to plan at all. We're dealing with such a case now, and of course, what it leads to is challenges. And when we're involved in probate litigation, that can get quite expensive, especially if the other side is challenging you. And family versus family, there are a lot of things that come out. You really don't want to make these things public knowledge, but when there is probate litigation, again, it is a public file, so you have issues with that. The other thing is a will. Well, yes, you can get a will online for next to nothing, maybe even for nothing. But everything goes through probate. Everything is public. Whereas with a living trust, the difference is everything is laid out. It executes immediately. You can plan for contingencies in the future. There are two types of living trusts, as you may know, the revocable and the irrevocable. The irrevocable, which is usually used for children or children who have gambling habits, drug habits, someone you want to take care of, you can decide when certain amounts of money are paid to them. You can do this also with a revocable, but the thing is it can be changed. Um, with respect to the irrevocable ones, they're more set in stone, and once you have them in place, you leave them alone and you can't do anything with them. The revocable ones I like a little bit better for certain reasons because they give you a lot more flexibility, especially if you update it, especially if you're in business, of course, because things change. You take on various things, you let go of other things. You want to make sure that everything executes according to your plans and desires. Now, one of the things I want to discuss here is how important it is to have an estate plan, not just a living trust. Because when somebody passes away, they have their own world, their own little bubble. They've managed everything. They know where everything is. They know all the passwords. They know where the skeletons are hidden. But the family that comes into this has no idea where to start. And this can be extremely challenging. So, what do? The best thing is to lay everything out. I've been involved with updating my living trust every 6 to 8 months or so because I'm involved in a charity, as many of you know, for abused dogs. And the company that funds that has a lot of dynamics. Things change, people change, goals change. And so you want to update not only the living trust itself, because the living trust is easy. You decide what you want to do, who you want to give it to, et cetera, et cetera, et cetera. But the more complex aspect of a living trust is laying out everything, all of your bank accounts. How do we access them? How much is in them? For example, in one case where we recently got hired, the clients just brought us a box and a half of files. We had to devote a filing cabinet for them or to them. We just have all the files there. And we had to figure out what's available, where, et cetera, et cetera. But what's even worse is until it goes to probate, the banks will not speak with you. Whereas if you had a living trust, of course, and this was a businessman, it quite surprised me, but if you have a living trust, then somebody has power of attorney and they can access this information immediately rather than waiting 60 or 90 days. Because the probate case has to be prepared, then you have to file it, etc., etc. So I would urge you to consider an estate plan, not just a living trust. You want to have something, and even if you don't own a business, you may have, for example, a situation one client has where they sold somebody the house, but they took back the mortgage. So instead of the person paying a mortgage company because they had bad credit, they're paying our client, who's now deceased. I mean, our client's family, and we need to have details. Who are they? Where do they live? What's the amount? What's the original contract? What's the percentage rate? So you want to have all of these details laid out, all of the bank accounts, safe deposit boxes. What can we expect to find in them? Now, of course, some things are going to be secret, but some things can be inventoried because we just dealt with one bank, and although the probate code allows access to the safe deposit box and an inventory of the contents, although you can't get, custody of them until the cases, the probate cases continued. But they wouldn't even do that. You know, their legal department, which didn't know the laws, just stated, no, we're not going to help you. And so you have to go to court and fight it. So it becomes very difficult. And I know from experience, um, there are two great challenges that we face with respect to living trusts. One of them is finding out what all does the client own, especially if a client owns something outside the country. Because although it's possible, you can hire private investigators and various companies to check on this. They're not always accurate. For example, we hired a company now to discover all of our clients' assets, and they basically had stated that there was no mortgage on the property, and when in fact there was $100,000 mortgage on the property, and it was placed about 4 years ago, but it didn't show up because a lot of private investigation is conducted by computer. So where this information doesn't show up, it becomes a challenge because especially if the estate is being split a number of ways, what are you going to do? Because you have to deduct the value of the mortgage from the value of the house when you're deciding what the split is. And then it becomes more complicated if somebody wants to live in it. So, if, for example, you have a family and it's very likely that one person may want to live in the house, you can provide them with the priority that this person gets first choice. If they don't want it, it's called right of first refusal. Goes to the second person, goes to the third person, etc., etc. But a lot of people regrettably don't realize how complicated it gets when they pass away. And money will change people, as you know. And so what happens is one person challenges the other, and then all of a sudden you have probate litigation, and you're spending a lot of money where it all could have been saved with a very detailed living trust and an estate plan that states, this is where I am at, this is the company I own, this is who I'd like to run it. If he or she doesn't want to, this person runs it. X number of shares to that person, X number of shares to that person. And that gets complicated too if you own what's called a professional corporation, like a law firm. You can't give it to just anybody, somebody has to be a lawyer. So there are complications that I would urge you to take the time and ascertain before it's too late. Because unfortunately, we've seen things happen to people at various ages. Anything can happen overnight. And two things can happen. You can die, or worse, you can become so disabled that you can't manage your affairs. And then what? What decisions are being made? Well, as you can imagine, many companies and a large number of assets have been annihilated because of wrong decisions or because of greed, because of people wanting the money. So there's a lot more involved when you're a business person or a sophisticated investor than if you're somebody who works a 9 to 5 job where your IRA, your bank account, and everything are very well organized and easy to locate. But once you start diversifying, having assets with a number of different companies, a number of different places, get to a computer, type it out, put it in your safe deposit box, or give it to your accountant, your lawyer for safekeeping, so that when something happens, you have, or they have, full access, and you have the comfort of knowing that everything's been done according to your wishes. That's the best I can share with you in terms of a personal conversation, some friendly advice, because we deal with a lot of nightmare situations, and they all could have been avoided Almost all of them could have been avoided if somebody put together a detailed estate plan rather than just stating, well, yeah, half and half. What does half and half mean? How do we split the house? I mean, the standard way is selling it. Maybe one person wanted to live there, but they couldn't afford to give the other person the other half, especially with house prices today in California as they are. So there are many, many contingencies, many unknown factors to consider. So given that, plan ahead. It's going to take you a couple of hours. But have a glass or a bottle of wine. Don't get drunk, but what I'm trying to say is relax, sit in a place, think it through, type it out, and all the best.